Good morning, Your Honor. Louis Hakeem here on behalf of the plaintiff.
Thank you, Judge. My name is Sheila Woolham with Lucero Woolham, and I'm here on behalf of the defendants.
Okay, and the defendants are the movement on both of the motions, I understand.
Yes, Your Honor.
Okay, you may proceed, Ms. Woolham.
Thank you, Judge. I'll go ahead and begin with the motion to compel since I can see that our court reporter is taking the record. This is a car wreck case. There was an accident on August the 5th of 2024 between my client, Kathy Stevens, and Mr. Hakeem's client, Hector Hernandez. Liability is disputed. The extent, the existence and extent and nature of his injuries are also disputed. In fact, we have we've made a counterclaim, so that there's a lot of disputes in the case. The defendants have asserted an affirmative defense of Mr. Hernandez's pre-existing injuries. One of the main injuries that Hector Hernandez claims is a low back injury, and he's received a good amount of treatment for that, totaling, many tens of thousands of dollars in treatment. So there's no question that his low back condition is in controversy in this case, and there's other injuries he claims as well. So, and I don't think that plaintiff disputes that Mr. Hernandez has a history of prior low back injuries and conditions. The problem here, Judge, is that none of this has been disclosed. It has been discovered piecemeal by following threads of information that were given in deposition testimony by Mr. Hernandez. And so what the defendants have, is a partial picture of the pre-existing conditions. So in my motion, Judge, I kind of gave a little overview of what we have been able to determine, and it's not insignificant. Mr. Hernandez has fell from a roof in 2009 and broke a bunch of bones. In 2016, he had a motor vehicle accident. He admitted in his deposition that he hurt his low back, but he said he could not remember any of the treaters where he went for injections and treatment. In 2018, he was seen for another motor vehicle accident, again at Del Seaton for low back pain. There was another fall off a roof in 2021. We have those Del Seaton records. They talk about low back pain and a potential brain injury where he received some imaging at Touchstone Imaging. Then we have 2023. He's at Del Seaton complaining of chronic back pain that has been exacerbated over the last year. And I think it's around this point in time that we start to see notes about low back compression fractures from one of these falls. I don't know which one. And then in 2024, which is the year of this collision, in February 2024, he is back at Del for back pain, reporting that it's been going on, low back pain specifically, 6 months, starting with an injury 2 years earlier. Now, none of those treaters that I just mentioned have been identified anywhere in plaintiff's disclosures or in response to interrogatories. So part of a good number of the interrogatories that I'm targeting in my motion to compel have to do with those questions about pre-existing injuries, treaters, primary care, all the things that we need to know in order to make sure that we have a full picture of what was going on over a period of many, many years and related to the low back. So in particular, Judge, within the Del Seaton records from March of 2023, there are a few pages faxed by a clinic called Community Health Center. And they're incomplete. They're just a few pages, but those few pages do indicate that Mr. Hernandez was seen there, at least at that time, for low back pain. he was complaining of chronic low back pain at Community Health Center in March of 2023. And those few pages that exist in the Dell-Seaton chart also reflect that he was prescribed medicine, and he was, the Dell-Seaton providers at that time recommended that he follow up with primary care. Now, I don't know who Mr. Hernandez was considered to be his primary care doctor, again, because plaintiff has refused to give answers to those questions in response to interrogatories and in disclosures. So that's where we are factually, Judge. And I don't want to speak for Mr. Hakeem. He filed a response, and I can address that in more detail later, but I will say it appears that the plaintiff has only presented evidence. Of course, it's the plaintiff's burden to present evidence in the form of testimony or affidavits when the plaintiff is the party resisting discovery. The only testimony that plaintiff has brought to the court are some excerpts from the deposition of the defense expert, Dr. J. Ellis. So there is no evidence before the court, no response by plaintiff to the particular interrogatory and request for production items that we are addressing. The plaintiff's only response is that based on the testimony from Dr. Ellis, plaintiff contends, well, these are totally different injuries. My back pain, my low back pain that I admit I had prior to this accident was non-radicular. And now, after the accident, it's radicular. But that's not, that is interpreting the bounds of discovery far too conservatively. That sets us up for a situation where the only time a defendant can get discovery into a pre-existing injury is if the plaintiff admits that it was exactly and precisely the same in location and scale and intensity and manifestation as it was after the accident, and as the court is well aware, that never happens. So the argument that these are two different injuries really is not credible. The other problem is that, of course, Dr. Ellis, our expert, has given a deposition without the benefit of full information. So plaintiff is trying to argue that, trying to resist discovery and then saying, well, Dr. Ellis gave this testimony, but Dr. Ellis doesn't know everything he needs to know. So I feel like this is a sword and shield situation. The third thing that I would bring to the court's attention is that, this is the pattern jury charge distinguishes damages for an aggravation of a pre-existing injury depending on what symptoms existed, when they existed, in the timeline. So clearly that means that a defendant must be allowed to get discovery into this information. The plaintiff's records after the accident repeatedly reflect that he is reporting to his doctors that his low back pain began with this accident, and his doctors rely on that. And they say, oh, well, if that's the temporal relationship, then there's causation. So again, the existence and extent of pre-existing low back pain and the treatment for it is clearly relevant and discoverable in a case where the claimant is seeking tens of thousands of dollars for a low back injury. So my motion is intended to, number one, seek a court order requiring the plaintiff to actually identify all these prior treaters. I know some of them. I don't know if I know all of them. I've only been able to find this out by subpoenaing records based on, again, little threads that were provided in depositions. These records have been provided to plaintiff, and yet he still has not identified these as persons with knowledge and has not bothered to respond to acknowledge this history. So that's one thing that I'm seeking. I am also seeking an order from the court for the plaintiff to produce a medical authorization for this community care health clinic where I know Mr. Hernandez was seen because of the few pages in the Del Seaton records. Plaintiff argues in his response that he is not required to produce a medical authorization unless one already exists. And he's relying on pre-2000 law and pretending that disclosures don't exist. The disclosure rule clearly provides that all reasonably related medical bills and records have to be produced or a medical authorization in lieu thereof. So I don't know where this is coming from, that the idea that that they expressly argue in their response that the court has no authority to order a medical authorization to be produced. And that is not correct. Obviously, the court does have the ability to do that. So, Judge, I think we could, I don't know if you'd like to hear from Mr. Hakeem more globally and then go through the individual items, or go through them now.
Well, you have about 4 minutes remaining of your, I think you said 30 for this, so that would be 15 each. So it's up to you.
Okay, Judge, I'll go through the interrogatories then very quickly.
Okay.
In these exhibits, I don't know if these are supposed to be uploaded to Boxy or not, but in interrogatories 1 through 4 or 1 through 5, in response to, so these are signature aviations interrogatories, are requesting information about prior injuries and prior treatment. These are clearly questions that are relevant to pre-existing injuries. Is the court, that is exhibit 1 in Boxy, Judge? I don't know if the court has access to that or not.
I do, but I have limited screens that I can open up right now. I read your
Okay.
motions before this hearing, so I'm familiar generally with the complaints. I don't think you need to pull it up.
Okay, very good, Judge. So interrogatories 1 through 4 sent by Signature Flight Support are requesting identification of prior treaters for prior accidents. Plaintiff has simply objected to these and said, I don't remember. What I'd like the court to do is to ask that those objections be overruled. And if the answer is I don't remember, that's fine. But the objections are inappropriate.
Okay. Well, I'm going to hear from Mr. Hakeem then, and we'll turn it over.
Yes, Your Honor. Obviously, I have a lot to say. I'll try to be as brief as I can. Ms. Woolham cross-examined Mr. Hernandez for 3.5 hours on these very issues. They've sent him 3 sets of requests for production, totaling 66 requests, 2 sets of interrogatories, totaling 27 interrogatories, and 1 set of requests for admissions, totaling 22. We've supplemented our disclosures 13 times, providing them information related to the claims in this case. The defendants have obtained more than 10 years of Mr. Hernandez's prior medical treatment, to include therapy records, urgent care records, St. David's Hospital, and Del Seaton. The subject of those records include a knee injury, which is unrelated to this case, colonoscopy records, constipation records, testicular problems that Mr. Hernandez was having, and low back pain complaints. Contrary to what the defendants have represented to the court, Mr. Hernandez has been upfront and disclosed these prior low back problems since September of 2024, which was a month after this crash, when he first went to his treating physician. He explained and disclosed prior injuries to his back, said in those records to his physician, I don't remember the name of the chiropractor I went to. I don't remember the name of the pain management doctor that I went to. When Miss Woolham cross-examined him in his deposition, she continually and repeatedly asked him these same exact questions. He told her, this is the treatment I remember receiving. I don't know the names of the places I went. She then sends him interrogatories after his deposition, asking the same exact questions that he explained to her in his deposition. He didn't have the information for. She's now here asking the court to order him to produce information that he said twice he doesn't have. Now, when we talk about what's reasonably related to the injuries in this case, Mr. Hernandez is claiming a lumbar injury that has manifested itself in numbness and tingling and radicular symptoms. All of the prior records that the defendants have for the 10 years before this collision all reference general complaints of low back pain. Those records also specifically exclude numbness and tingling. They have done those records even up to 5 or 6 months before this crash, all specifically say there is no numbness or tingling that's reported. And so to say, oh, we just have to rely on what the plaintiff says is untrue. It's all documented through thousands of pages of prior medical records that the defendants have obtained. And so I'm all for discovery that's reasonably related to the case. At some point, the discovery becomes harassing and oppressive. The defendants have sent the subpoena to this community care clinic to see if Mr. Hernandez had a prescription for pain medication related to low back pain. Dr. Ellis's testimony is extremely important, Your Honor, because he was hired by the defendants. He had access to over 1,000 pages of Mr. Hernandez's prior medical records, all which contain exactly what I just explained to the court say. And he said, these are two different injuries. He said just having general complaints of low back pain is not the same as having low back pain with radiculopathy. Because when you're dealing with radiculopathy, it indicates that there is some structural damage either to a disc or the nerves in the spine. Just generalized low back pain is a muscle strain, a muscle soreness. And so when we talk about what's reasonably related, they've got all the records, they've got everything that they want. How did they get the identity of these providers? Through Mr. Hernandez. And so it may be inconvenient. I mean, and we have to look at this kind of in perspective, Your Honor, because if all of these thousands of pages of records that they have, and Ms. Woolham has said he has these low back problems going back for 10 years, 15 years. If that meant something in this case to her, we wouldn't be here right now, because she understands it doesn't mean anything to their case. And that's why she's trying to continue to try to find more information. So if we look at each of these requests, why didn't I respond to each individual request? Because I stand by the objections. They're seeking information that is irrelevant and not reasonably calculated. If we want to talk about the authorization, again, their complaint with Community Care Clinic, who won't produce the records without an authorization, is with Community Care Clinic. It's not with Mr. Hernandez, because their own expert says that information is not the same as this claim. And so if they want to file a motion to compel against Community Care Clinic to honor their subpoena, okay. But the production of a blanket authorization to them is not the appropriate remedy. When we talk about unrelated medical treatment, that information is privileged. It's covered by the physician-patient privilege. And again, if you go through each of these items, I mean, she only referenced the first 4, but he, again, subject to that objection, says, I don't know the information. And throughout his deposition testimony, he said, I don't know the information. I don't know how the court wants to handle the rest of, you know, these other 30 or whatever requests that she's included here, but I do have responses to all of the lost earnings information and
Okay, well, I mean, go ahead and tell me
Sure.
whatever
Sure.
arguments you have.
You bet. So there is a loss of earning capacity claim in this case. Mr. Hernandez is self-employed. He's been self-employed for a handful of years. He was self-employed at the time this collision occurred. Miss Woolham asked him in his deposition, do you have any records or paperwork that you could refer to help you remember how many days you missed work? He then explains to her, I am a small service business. If I can't answer the phone and I miss it, then that's fine. Nothing happens. I don't keep a record like a big business does because there's no weekly pay log. She then asks him again, do you have any records that we can see that would show us how much time you missed from work? He says, again, because he's been asked this question 3 times at this point, if I'm not there, the business doesn't exist. I just deal directly with the customers. When an order comes in, I just don't keep track of logs like that, is what he explains to her. So what does Miss Woolham do then after the deposition? She comes and sends him all of these requests for production, asking him for documents that he just told her in his deposition he doesn't have. And now she's here asking the court to order him to produce records that he said in his deposition he doesn't have. And so if you look at the breadth of the requests that she's asking for related to the lost earnings, she's asking for years before the collision. That's overbroad and it's irrelevant, first of all. Second of all, the actual category of damages is not straight lost wages. It is a loss of earning capacity claim, which includes a variety of different things, including a wage rate. And so the way that Mr. Hernandez has calculated in his disclosures, his loss of earning capacity, which is the claim, is his approximate earnings before, his approximate earnings after. Do I wish he had documents to support all of that? Of course, it's from our side, sure. That's cross-examination for her. It's argument for her to the jury. There's no documents here. But as far as Mr. Hernandez is concerned, he's already explained twice he doesn't keep those types of records. Related to the tax returns, there are multiple cases, Your Honor, that say discovery of tax returns is looked down upon, they're privileged. The 2 cases that I'm relying on are the Sears Roebuck versus Ramirez case, which is from the Supreme Court in 1992. And that case relies on Crane versus Tunks, which is a Supreme Court case in 1959. And so, you know, she's asking for complete copies of all of his tax returns. It includes information related to his dependents. It includes information related to his spouse. It also would include a variety of other personal private information that doesn't have anything to do with the loss of earning capacity claim. And so, Your Honor, again, he's tried to comply the best that he can with the requests that have been served. He's been forthright going back to September of, a month after the crash about his past medical history. Does he remember every single doctor visit he went to? No. And I don't think anybody does. And so I'd ask you, Your Honor, to deny the defendant's motion. Thank you.
Okay. All right, Ms. Woolham, on this motion, you have just a couple of minutes if you have any final words.
Thank you, Judge. I'll be very brief. It seems that Mr. Hakeem believes that if a question is asked in a deposition, then another party can't send a request for production or an interrogatory. That is obviously not the law. When we have written discovery requests out there, that creates an ongoing duty to supplement, and that's why we do that. So the fact that Mr. Hernandez alluded to some of these things in his deposition is really irrelevant to whether the written discovery should be responded to. And again, they haven't. They haven't supplemented with any prior treaters, even though we've found a bunch of them. So the argument, I think the argument, Mr. Hakeem acknowledges that his argument is that the additional prior low back injury and pain records should not be discoverable because so far in the records that I do have, there's no evidence of radicular pain. That is an illogic, that doesn't make any sense. I'm still entitled to see the additional records that I know are out there regarding low back pain. And for all we know, they do reference radicular pain, if that's significant or not. As far as the lost earnings and lost earning capacity, Judge, again, I guess I would just say that I believe the cases say that Mr. Hakeem is referring to look down on discovery of tax returns when there is a less intrusive way to get the information. But what Mr. Hernandez is saying is, I got nothing. I don't keep records. I have nothing. So of course, that's where we are, is requesting tax returns so we can see a before and after and try to get some idea of what this lost wage and lost earning capacity claim looks like.
Okay. All right, Ms. Woolham, what I'm going to ask you to do, I've reviewed the proposed order that you have on your motion to compel, and I'm going to ask you to revise it in this manner. For each request that is the subject of the motion to compel, I need you to simply cut and paste the request into the order, and then the response and or objections to that request. And then typically folks provide a blank for the court to indicate overruled, sustained, leave a blank for me to provide a ruling on each and every interrogatory or request for production that are at issue here and submit that order. So, you know, you've kind of argued globally and then you've taken some kind of issue by issue, but I in order to appropriately rule on these conflicts, that type of order is going to make it easiest on me, so I'm not shuffling between motions and responses and discovery and responses. Does that make sense to you?
It does, Judge. Thank you for that direction, and I'll do that immediately.
Okay. All right, it can be emailed to Ms. Seeger for my review, and
Okay.
so I'll withhold any particular ruling until I can examine each and every request with the response, and then I'll let you know whether those are sustained or overruled, as far as the objections that have been launched. Okay?
Yes, Your Honor. Thank you.
Okay. And then we're going to move to your special exceptions motion, for which I think you did not need a record.
That's correct, Judge.
Okay, so I'm going to let Ms. Simon take a little bit of a break because I know the other hearings do want records. So you could step away for a moment until we need you again. And Ms. Woolham, you can proceed on the special exceptions.
Thank you, Judge. We are specially accepting to plaintiff's 7th amended petition with specifically as to the gross negligence allegations. They are just boilerplate. They say that Signature Aviation USA LLC and Signature Flight Support LLC were grossly negligent, and they recite the elements of gross negligence. The problem that exists with this is that I cannot tell. It is unclear whether this is a claim that the defendants were, these alleged employer defendants were directly grossly negligent by some manner and means, like grossly negligent hiring, training, supervision, or is this an argument that the driver's gross negligence should, under some theory, be imputed to a corporate entity? And it's important that I know that specifically with respect to each of the corporate entities so that I can craft appropriate dispositive motions. Right now, it's just spaghetti on the wall. Both corporate defendants were grossly negligent. So I'm just asking that those pleadings be refined to state what acts, if any, each defendant was grossly negligent in, according to plaintiff, and whether this is an allegation that there's some theory that would support imputing, like ratification or something like that.
Okay. All right, Mr. Hakeem.
Yes, Your Honor. If you look at paragraphs, and this seventh amended petition was filed at the defendant's request to try to clarify this issue. I thought that I had. But paragraph 16 and 17 set out the gross negligence claims against both the individual defendant and the corporate defendants. In paragraph 16, it identifies the gross negligence allegations against Ms. Stevens, and then in paragraph 17, it identifies the gross negligence allegations against the Signature Aviation defendants. And I thought that it was clear when I added, the cross-reference to these other paragraphs where it cross-references just the negligence claims, and it includes exactly what Ms. Willem says she didn't see. Negligent hiring, negligent entrustment, negligent supervision, negligent retention, etc. And so, yeah, I mean, that I don't know how else to describe it. I guess I could, in this gross negligence paragraph, instead of cross-referencing these other paragraphs, I could just copy that and put in here. They were grossly negligent, as far as these allegations go. But I mean, there's no interpretation of this that Miss Stevens was any type of vice principal that would, impute that gross negligence to the corporation.
Okay, well, let me jump back to the other paragraphs that are
Sure.
referenced here to see if I can make heads or tails of it.
Yeah, I mean, paragraph 17, and as I read it right now, it looks like it's a typo. Paragraph 15 should be paragraph 14, and I can get that, cleared up. But paragraph 14 is pretty detailed as far as what the allegations against the corporate defendants are.
Okay, but those are all just general negligence theories.
Sure, right.
I
Put
think,
them on notice, right.
yeah, I mean, I think what Ms. Willem is saying is, what is it that someone did that rises to the level of gross negligence? And I don't know that just referring back to the regular negligence paragraphs really accomplishes that, because those are two very different things under the law.
Well, the point of it is it puts them on notice of the basis of the gross negligence claims. And so when we look at what is the gross negligence, it's identified in paragraph 17, where it says that their negligence, as described earlier, was more than mere momentary thoughtlessness, error, or inadvertence. And then it goes on to lay out what the basis for the claim of gross negligence, that when objectively, from their standpoint, at the time of its incurrence, their actions involved an extreme degree of risk. I mean, again, I can copy and paste that in there, but as far as what else under the pleading requirements could be put in there other than, proving my case, or my expert's deposition testimony that he gave that said they were grossly negligent. I mean, not sure how to cure their complaint. I mean, we are just a notice pleading state. I mean, she clearly knows the claims against them.
She knows what the claims are. She doesn't know what the basis is, I think. I mean, you recite the legal standard for gross negligence. She knows what that is. I think she just wants to know, what are the facts that you're relying on? What are the acts of gross negligence? And that I don't see those in any of the paragraphs. So I'll grant the special exceptions.
And Judge, I want to make sure that the court, that this is included in the court's order, and perhaps I need to revise this order as well, but it's important that the gross allegations be specific as to each of these corporate entities, because one of them, Signature Aviation USA, LLC, there's absolutely no evidence that this entity employed Kathy Stevens or controlled the vehicle. So I need to be able to attack those separately. So that's part of my part of my motion, and I'll make sure that the order is drafted in that fashion. But I just want to bring that to the court's attention.
Okay, I think each defendant's entitled to the factual allegations that provide the basis of the gross negligence claim. So why don't y'all confer over the form of the order, and assuming hopefully you'll reach agreement on that, it can be emailed to Ms. Seeger.
Okay, thank you, Judge.
Okay. And let me see. This is a 2024 case, and you are set for trial in February of next year. So just a reminder, you need to mediate before you get a jury trial. So best of luck to you. Y'all are excused from the virtual courtroom.
Have a good day.
Thank you,
Thank
Judge.
you so much.
Bye-bye.